Welcome back to Sunrise. They're keeping our focus on the Senate Mace theft and the attendant drama associated with it. Well, Prof, I was going to ask, some of the arguments that has been put out there by perhaps supporters of Senator Omar Agege and those who say, well, the Senate brought this upon himself. And then there was a statement that was put out there which said that Senator Omar Agege attended the sitting because he was advised by his lawyers to do so. Now, if you were his lawyer, for instance, or if your client happened to be in that kind of situation and you had gone to court, would you advise that person to go to that proceeding?
Well, counsel that gave that must have knowledge that is not in the public domain. Otherwise, from the facts that have been thrown in the public domain, there are rules that regulate the attendance of members, even in the Senate. And where a member has been sanctioned by a peer, review system of the Senate, the person must, abide by the openly, announced and televised sanction. With respect to that, I think the law is not as subjective as that. There is some objectivity to the law. So what are the guiding, legal norms? Of course, we have the Constitution that constitutes the Senate and gives it authority to formulate its rules, and those rules are binding on the members. In the absence of any court order that, will have given authority to that kind of counsel, a substituting order ought to be upheld by a member of the Senate. Not to take the law. The moment you go into the realm of self-help, advising counsel into self-help, a client into self-help, you expose that client to, conduct himself in a way that will violate, at least breach the peace, which is a violation of the law, and then, of course, take the law into the social and the commission of crime. In this process now, they broke into the Senate, they took the mace, they, as has been said, they kidnapped a senator for some time and all that. So basically, once you go into the path of self-help, you are likely to find yourself on the other side of the law.
I know that I think it was an Abuja High Court which had ruled concerning Senator Lindome's case about a similar circumstance. But does this action, this singular action, in any way weaken or does it jeopardize the case that his lawyers may have in court? Senator Omar Agege.
Well, it depends on the claim that they have in court. It might be separate from what has transpired. But what has transpired before all of us has involved the commission of a crime. Basically, those people who came to take the mace did not have the authority. They violated the hallowed grounds of the Senate. They kidnapped. They breached the peace. They've put the whole democratic process into, into shame.
Well, does this exonerate Senator Omar Agege from any wrongdoings if we look at it from the point that his lawyers were the ones who advised him to go back to the hallowed chambers?
Well, his lawyers might have advised him to go back to the hallowed ground of the chambers. But the bottom line is, on what basis would they give that counsel? And those are the facts that may not be known to us. And those facts could be before the court. But that has not been made public as of now. But on the face of it, he's a member of the Senate. The Senate, at a plenary session, read out sanctions against him, which was binding on him as a member of the Senate.
Let's hypothesize for a bit. If he had served the Senate Committee on Ethics, maybe by extension the Senate, as someone that restrains them from taking any further action as a result of the fact that the case is in court, they should stay action. Will that in any way justify him coming back?
Basically, not. If he served them, he's supposed to go to the court and report that, look, we served them, they refused, and base his action on the court order. It's not supposed to be interpreting. If we are all doing that and interpreting the law as we feel to favor ourselves, there will be breakdown of law and order.
So showing up there can be interpreted or is tantamount to interpreting the laws by himself?
Based on the counsel of his lawyers. And I think that is self-help.
What I think they also have tried to do is to dissociate the senator from the actions that happened. because there are statements flying around saying, well, the senator woke up, he got there, he went to work by himself, asked the law-abiding senator, and people came in there, snatched it, he was not the one. How easy or difficult is it, do you think, that people who saw what happened and heard that perhaps those who came were allegedly associated with him, is it easy or difficult for him to dissociate himself from the event that happened?
Well, let's, do a photo screen, of it. He shows up, they show up. The reasonable mind will connect the two. Our law presumes everybody innocent until the otherwise is proven. So what it means in essence is that it could be coincidence. The duty is on the police and other security agents to produce those people to make the connection. So if they investigate and they are able to show connection, either they are able to establish from the testimony of the culprit that he is the one that sponsored them. In the absence of that, then we have to go by the story of the senator that, no, I had nothing to do with it.
Those visuals that we see on TV, would they be tenable in court?
Of course, they will be tenable in court if there is any proceedings, either criminal or whatever, against them.
So in this situation where Senator Omagege has obtained a restraining order from the court to stop the police or the DSS from arresting him, what should be the next line of action?
I think the order of the court must be in relation to the fact that he had filed an action earlier with respect to these proceedings. However, if the investigation of the IGP or the DSS shows culpability on the part of Omagege, I don't think that
that's the image we're talking about. Yes. So he shows up, he's going to his seat, as we can see there. So I look at that mace now being snatched.
And this is the same, the people taking the mace came in with him. But now...
Can we assume that at that point? Because if
it looks like they came in with him. Okay, so...
It looks like.
But it's hard to say.
It looks like they came in with him. That's why I'm saying that, look, it looks like he was going about, he was still greeting.
Okay, but look at the look of some of the senators. They were shell-shocked.
Yeah, because
he was going straight onto his seat.
There could be that presumption.
Could it be that he's preoccupied with, look, I'm just here to go to my seat, whatever you guys...
You know, the bottom line of it, you have to understand, is that once you are alleging that he's involved in the commission of crime, we must prove beyond reasonable doubt. It's not on the balance of probability or suspicion. We must have corroborative evidence that links him to the commission of the crime.
When you said the court order must be in line with the fact that he probably had filed a case before.
As a matter of fact, he had filed
a case yes. About his suspension.
About his suspension.
Not about the mace being...
Not about the mace.
So can he still be questioned as regards... Why would he now file a case now to get a restraining order when it comes to the mace for him being arrested?
Basically, it must be that on the premise of the earlier file case, he believes that, look, the police are trying to harass him with respect to this case that he had filed.
But then there are two different cases.
There are two different. That's why I made the point that the case going on, the restraining order may relate to that. But with respect to the commission of crime, if the police or DSS have evidence of his commission of crime, they will prosecute him on that. It doesn't bar them from prosecuting him.